against Rickie Cedeno.
Good morning, my lords.
Good morning, Mr. Harrilow.
I appear on behalf of the appellants in this matter with Ms. Sian McGibbon and Mr. Omar Sabah, and Mr. Robert Strang appears on behalf of the respondent. My lord, before I begin, may I thank the board for granting permission and expediting the appeal. I know that the appellants are watching online. My lord, I'm going to cut to the chase, so to speak, and set out my position in summary. What we say is that any conviction in criminal proceedings should be returned according to law. In this appeal, the convictions we say have not been returned according to law, and the decision is erroneous in point of law. That is the language used in the Summary Courts Act, which is why I give my lord that phraseology. And for any note, it is at E-Bundle 475, which is section 132H of the Summary Courts Act.
I'm sorry, I was just trying to log my computer in and I missed the page.
It's E475.
Thank you.
And all it does is it gives the board the reference for the grounds of appeal that are permitted by the Summary Courts Act. And so in relation to conviction, we say that the decision is erroneous in point of law. And in relation to sentence, as a separate point, this is 132J on the same page, we say that the sentence was unduly severe. There are, my lords, three parts to our oral submissions, and we're not going to repeat everything set out in our case, because I know the board will be familiar.
Can I
yes.
I wonder if cutting to the chase, there's something to be said on it for it on behalf of the court as well as counsel. Now, Mr. Strang, I think, accepts that the sentence was excessive insofar as it covered a period more than 6 months
yes.
prior to the date of the complaint. It's occurred to me that another problem here is that the complaint itself was charged the appellants with failing to demolish and remove the relevant building during the period ending on the 4th of August 2008.
Yes.
Now, if that's the charge, and that's what the person is convicted of, how can they be sentenced for a continuing failure after August the 4th, 2008?
We agree, my lord, and that is why one of our arguments in relation to sentence is that the sentence ought to be confined, if the board is with us on that alternative argument, to the dates in the charge, starting with, of course, 6 months, only being able to go back 6 months from when the charge was actually laid. So that's why it's a much shorter period, which we say ought to be the approach if the conviction is upheld.
Yes. Can I ask, is that you may want time, I don't know, to think about this, Mr. Strang, but I wonder if it's in issue. They weren't charged with a continuing offence. They're charged with an offence between two dates.
Well, my lord, I do have an answer to that. I've dealt with it briefly in my written case. The answer can be found in the Barnett and Kamyak case, which says that the end date in a complaint isn't material. And when it comes to sentencing, it's a matter for the court to establish when the offence ended, if it did end, when the commission of the offence ended.
Right, and I'm sorry, the case you're relying on is...
Barnett and Kamyak.
Oh, yeah. Barnett and Kamyak. Okay. Well, we'll have to... That's on page 578. All right, we may need to look at that quite closely.
My lord, there are, as I indicated, three parts to our oral submissions. The argument we make in relation to conviction, this is part one of the argument, is essentially twofold. A, that the two offences that the appellants were convicted of was plainly wrong, having been misled by the respondent, and the Court of Appeal's approach to them was also wrong. B, that the complaint was in any event time-barred. The second part of the argument is in relation to sentence, and that too is twofold. We focus on A, that the sentence of imprisonment in default was unnecessary and excessive, and B, that the sentence overall failed to reflect the long delay. The final part of the argument is going to be very much shorter because essentially it relates to the magistrate's failure to give reasons that affects both conviction and sentence. And we feel that when we've dealt with conviction and sentence in our primary submissions, that can be taken much, much shorter. But essentially what it comes to is this. The Court of Appeal has returned a verdict of acquittal and a verdict of conviction. That is in the last page of the judgment. It now having been conceded that there is only one offence, it begs the question, what have they been acquitted of? That acquittal is not appealed to this board, and if, therefore, there is only one offence, then that must be fatal to upholding the conviction at this stage. So, my Lord, can I deal with the concessions, because I know that there have been a number of them, and I deal with them briefly because they are, of course, welcome, but what we say is that this is the first time this number of material concessions has been made, that there is only one offence, and that the magistrates could only have gone back 6 months prior to the complaint. We say it is unsatisfactory because it's come 20 years after the Town and Country Planning Authority identified the extension being put up. And we say that those concessions should have been made at the earliest possible stage in the Magistrates Court, and certainly by the time of trial in 2017, at the very latest, before the Court of Appeal returned judgment in 2021, and to leave it to concede those matters before the board introduces an element of unreality into this case, where the liberty of the defendants was put in jeopardy by the sentence. More concerning, and this we do invite the board to consider, is that at the permission stage, when we sought permission from the board, this is at the board's bundle at E236, the respondent opposed permission being granted, stating in short terms, this is 236, the respondent's contention that the Court of Appeal's approach and overall decision in relation to the magistrate's conviction and sentence is correct in law and on the facts. The Court of Appeal properly and fairly dealt with the matter of the overall sentence. Then later, after permission had been granted, in the notice of acknowledgement, the respondent merely ticked the box, this is at the bundle 239, to simply say that it would ask the board to dismiss the appeal with no distinction as between conviction and sentence. My Lord, bearing in mind that this is a criminal appeal, this isn't satisfactory in any way, shape or form, because it could have had a direct impact on the submissions we framed in the case for the appellant and how we would have prepared the appeal. And so we would invite the board to consider that in relation to the concessions.
May I ask this?
Yes.
Were we otherwise with the respondent, what consequence would the matters to which you've just referred us have?
Well, my Lord, it concedes that if you were with the respondent, what we say is that when you actually look at the overall test, if you like, or approach as to whether the conviction is safe or not, the fact that the respondent effectively misled the magistrate into this position and maintained that position in the Court of Appeal, we would say should have a direct effect on how you evaluate whether the respondent's position in upholding the conviction is satisfactory, to use the old terminology. And unlike
hardly
the
amount to
criminal...
an abusive process, would it?
I'm sorry, my Lord?
It would hardly amount to an abusive process.
It wouldn't amount to an abusive process, but it would, which is a different test, undermine, we say, the safety of the conviction, because the way in which the courts proceeded in law was completely erroneous.
Well, you'll help us, no doubt, as to why that is so, subject, of course, to the other points which remain an issue between you.
Of course, and it may be that when I deal with the conviction parts that I answer some of those questions that
Thank you.
the Lord has highlighted. So can I deal first with the two offences point? in relation to conviction. The respondent has made the concession that this creates only one offence. But what they argue is that the magistrate, in fact, only convicted each appellant of one offence. But we say, my lord, that the transcript as a whole, when one looks at the material parts of what the magistrate decided, demonstrates that they are wrong about that. And the critical submission that was made by the magistrate, made by the respondent and accepted by the magistrate, is at page 56 of the bundle, and it's lines 44 to 48 on page 56, which is to this effect. Now, if your worship would look at section 18 of the Town and Country Planning Act, please, and then they refer to where section 18 is in the tab. Your worship creates two offences. It creates an initial offence and a continuing offence, please, your worship. Then if we go on to page 57, lines 7 to 10, the respondent goes on to explain that the second offence, the continuing offence, and says this: that is, your worship, after the first day after the compliance period, please, your worship, therefore, your worship, the continuing offence occurs on the second day, after the requirements of the enforcement notice remain unfulfilled. So what we say, my lord, is that when you scrutinise that, it's pretty obvious that they are making a submission that there are two offences, one initial, one continuing. And then when you look at what the magistrate did in dealing with that, this can be found at page 59, lines 41 to 45. The magistrate said, yes, I think the reason I would have preempted State Council at some point, it's because I too did some preparation in advance of today, and then these critical words, and I find that the State Council's submission are with merit on both points, and therefore I find that there is a case to answer. So two offences and time limit were determined as against the appellants.
Oh, but there's only one offence charged.
Of course, absolutely, I agree.
And the order, the record of the conviction, the extract conviction, simply records that they were.
I'm going to deal with that directly, my lord, because we've been proceeding on the basis that that was an order, and we've certainly referred to it as such, but now on an examination of the Summary Courts Act, it appears that it's some sort of minute. But if I may, when convicting the appellants, just to complete this point, this is at E64, page 64, lines 33 to 40. She then goes on to say, Mr. and Mrs. Silochan, I have to take it incrementally. Your attorney has essentially relied on the same submissions he made at the no-case stage, and Miss John, in essence, has relied on the same submission. Underline the words same submission. The only difference between the two considerations at the close of the prosecution case and the close of the case for the defence would be the relevant standard in the criminal law. And then she goes on to say, at lines 48 to 49, so you are therefore convicted, both of you, I'm sorry, you are both found guilty of the offences, plural. Now, the combined effect, we say, of the respondent's submission, the magistrate's approach in accepting it, achieved, although that is not, I accept, my Lord Reader, that is not what was charged, 2 for the price of 1. And so she did, in fact, convict of 2 offences. And if there was any doubt about it, then when she comes to sentence the appellants, this is now at page 70 of the bundle, lines 3 to 10, she says, I find that the appropriate punishment is, 70 lines 3 to 10, I find that the appropriate punishment is as follows. You are convicted and fined, and this is for each defendant, convicted and fined $700, and this is for the initial offence of failing to comply, so she's treated it separately, that's $700 each, and then she goes on, as it relates to it being a continuing offence, further fine is imposed as follows for the period 18th of January 2006 to 17th of March 2017 $200 per day. So we say that it is not possible and unsustainable for the respondent to say that she only convicted of one offence. And now, dealing with what my Lord has said about the minute, could I invite you to look at the minute, which is at 74, which is the only record we have of the magistrate's account of her decision.
I'm wondering where we're in a sort of Alice in Wonderland world.
We are.
And I'm wondering where it's going. Whatever she may have said, her powers were, her jurisdiction was limited by the terms of a complaint that she had in front of her. And the complaint charged a single offence.
Yes.
If I may ask, what does it matter what she said?
Well, it matters what she said, my Lord, because it is the oral decision, as we will demonstrate, that is relevant here. So if she says, I'm convicting you of 2 offences, the minute doesn't cure it.
But she can't have convicted of 2 offences.
No, it's erroneous in law, and that is our point.
And that's conceded.
Yes, but in doing so, they then say, but you can uphold the conviction anyway because of the way in which the Court of Appeal has approached it. Now, how can that be? We're still in Alice in Wonderland, just on the other side of it. We don't accept, my Lord, that you can sustain a conviction in this way, where the magistrate is saying, I'm convicting you of 2 offences. And it matters what she said. And if I may deal with my Lord Reed's question.
Why should the court intervene? Nobody is disputing the facts. Everybody knows that this building was not demolished, and therefore there was a breach of the enforcement notice.
Yes, but my Lord, for the purposes of proving the criminal offence, you can't convict of 2 offences and return a verdict in that way if, in fact, only 1 complaint has been charged. I can find no authority where that has happened, still less an authority where it has been upheld on appeal. And I hear what my Lord says, but if I may show you why we say this may be an important point and may persuade the board that there's perhaps more in it. If you look at what the magistrate recorded at we're not sure about this. This is E74, the document that my Lord referred to. We don't know when this particular document was drawn up or by whom. It may have been done by a clerk. It does not contain the date stamp that you see on the very next page, which is the notice of appeal, which is normally what one would expect to find. When that notice of appeal was filed, my Lord, it was filed in relation to the oral decision that had been announced by the court. And this minute was not available on the 24th of March 2017, and it was certainly not accepted by the Court of Appeal as a written decision of the magistrate, because we know from their reasons that they addressed the issue of the magistrate having given no reasons. And so it was perhaps unsurprising that the respondent in the court below took it as read that in fact the respondents had been convicted of 2 offences. What we would invite my Lord to look at and to consider is that when you look at the minute at 74, the first thing you'll notice is not a certificate of conviction. And we know that because if we look at the Summary Courts Act, and this is at the bundle 503, isn't it? I think it is 437. Sorry, forgive me, my mistake, 437. And this is section 67.
So what is the origin of the document at page 74?
Well, we don't know. It appears to have been drawn up by a clerk, we think, after the event. But if you look at this is how it's supposed to work, my Lord. If you look at 437, 67 subsection 3 records how the procedure is to be dealt with. If an order is made against the defendant, a concise minute or memorandum thereof shall be forthwith entered in a book to be kept for that purpose, and if necessary, an order in the proper form may be drawn up at any time thereafter. Now, we know what the proper form is because if you then look at page 503 of the bundle, this is the requisite form provided for by the Summary Courts Act. This is the document we should have. And in neither the Magistrates Court or the Court of Appeal was any document like this drawn up. So all we have, as I say, is the oral decision.
Well, isn't that the document at page 74, the minute recorded in the book?
We don't know. It seems to have been drawn up from something, but it's not the extract from the book. It's not a photocopy from that document as we understand it.
Was this point taken at any level below?
My Lord, it's something that no, it wasn't taken below, but I draw it to my Lord's attention because we've been proceeding on the basis this is somehow an order. It was never accepted as such by the Court of Appeal, but now that we've examined how it all operates, we know what we should have and what we don't, which is the certificate of conviction in Form 10. But the reason we say it's relevant, my Lord, is that when you look at what the court decided, in other words, the verdict, it is the verdict that we say that matters, and it's the oral decision that has been returned. And we say that that's put beyond doubt in the case of Ex parte France, which, if I can take the board to it now, it's page 1115, forgive me, 1114.
Just before we leave, I'm sorry, before we leave section 67.
Yes.
You took as a subsection 3, it tells us that there's to be a concise minute or memorandum entered, and if necessary, an order in proper form may be drawn up at any time thereafter. Now, subsection 4 then tells us how a defendant who wants to have an order formally drawn up can request one, and it lays down the rules relating to that. Is that what's meant by, is that what the words, if necessary, in subsection 3 relate to?
We consider that, my Lord. We say no, because if you are appealing, which you have to do within a certain period of time, the necessity of providing both reasons and the order would then arise. And so that is how we say subsection 3 would operate. So yes, if you're not appealing and you then want an order, then you can certainly request it. But once you have appealed and you've asked for the magistrate's reasons, or will add further reasons when you get those, add further grounds if you get those reasons, the triggering section is the appeal being lodged. So then it would be necessary to provide both reasons and the certificate.
And can you take us to where we find that?
Well, my Lord, that's the submission we make in relation to subsection 3, that if you are going to... Well, let me take the board to it now. If you look at section 130...
Where do we find that?
this is page 473, forgive me, my Lord. 473.
Thank you.
I mean, this touches on the last argument we were going to raise. But section 13B, subsection 1, is the requirement for the magistrate to provide reasons. And they are required to, on the receipt of the notice, draw up and sign a statement of reasons for his decision. Mm-hmm. And as we understand the way the sections operate, when those reasons are provided, if an appeal is lodged, then the Form 10 comes along with it.
But that's just a matter of practice, is it?
As we understand, that is the practice. But as I say, it wasn't fatal for how the case proceeded on appeal, because neither the Court of Appeal didn't have one, and they didn't issue one. And that was a question raised by the registry as to whether we had an order. We didn't. All we had was the judgment. But so much could have been perhaps resolved, my Lord, because had we had the certificate of conviction, which has to be authorised by the magistrate, we may have had clarity as between the reasons given and the actual order made, verdict issued.
Could I just orientate myself around another issue? And I'm sorry for interfering at the moment. At page 1085 is Hodgett's case.
Yes.
Where the House of Lords gives directions or an indication of how you actually charge a continuing offence. And in that case, the continuing offence was charged on and since the specified date. And in short, because they said that that was appropriate, the better practice would be to charge it between two dates.
Yes.
And that is, in fact, exactly what is the practice for indictments set out in Blackstone's paragraph D 11.32
Yes.
and onwards. So the fact that it's a continuing offence is apparent from charging someone
A period.
over a period of time.
Yes.
So the person charged, because it's between two dates, knows that this is a continuing offence.
Yes.
And wasn't that done in this case?
Well, it was done in the framing of the complaint. We don't take issue with that. What we
Yeah.
take issue with is the construction that's been put on how those provisions operate. And we're going to deal with that. In fact, I'm about to deal with it.
But do I understand you as accepting that the complaint actually charged a continuing offence?
Yes, it covered a continuing offence.
And so that those accused of the continuing offence knew that when they received
It would have been obvious from the complaint. And can I, if it helps the board, we're not suggesting that either the charge or the complaint could not have covered a continuing offence. What we say is the construction that has been attributed to it is wrong because of how Section 18.1 has been framed. And we would like to deal with that. But can I invite the board? I was going to give you this
and do
reference
just
to-
follow up with this. But with all the numerous continuous offences that exist in this jurisdiction, that's the procedure that's followed.
It certainly, well, I wouldn't be too quick to concede that is the procedure that's followed. It certainly flows from some of the decisions we've looked at. But what is critical and what we'll be able to show is that when you look at each of these authorities, that's not the basis they're determined. They're determined on the basis of the actual language used in the Act, creating the offence and then how it relates to timing. And we feel that when we show the board, because we know that there are a number of authorities the respondent relies on, what is going to be immediately apparent is that it does not lock and engage the first day after the notice expires for compliance, which Section 18, subsection 1 expressly does. And this is why, I'm going to come to it.
But you don't need the magic words in the complaint on and since a specified date.
The complaint is irrelevant. It's actually what's said in the statute, we would say. That's what's important. And that's why we focus less on the complaint and more on the statute. But if I can take you, my lords, to Ex parte Franks, which deals with this point in relation to bear with me. It's page 1115. And it's, I hope, answers my Lord Reed's question about the tension between the complaint and the verdict. So it's 1115, and it's the last paragraph, middle of the paragraph, where Justice Widgery says, where, however, the chairman of the justices announces the decision of the bench, it is this oral order and not the written register of convictions which the applicant must seek to quash. Whereas in this case the oral decision was a speaking order and gives reasons which discloses an error of principle, certiorari will go. And we have, as I've illustrated, when the notice of appeal was lodged in the court below, was lodged against the oral reasons announced. And that is why we say it is material, and therefore you can perhaps not disregard, but lend very little weight to the minute that is drawn up, which, as we've demonstrated, is not even in the appropriate order. So, my Lord,
That seems to me to conflict with the general principle that the oral decision or reasons given by a judge aren't finalised until an order is actually made of the court.
in which case we don't have a final order at any stage in this case. mean, that's why I draw. This is the problem. I mean, there seems to be, I say it very respectfully, a degree of lack of formality in how this case has been dealt with by the courts below. I would have thought that as soon as an appeal is lodged, reasons are required by statute, the certificate of conviction would go along with it. That would seem to me to be the proper practice. And even if that wasn't followed in this case, as I say, it hasn't been fatal to the appeal. The Court of Appeal said, well, we don't have reasons, we don't have an order, but we're going to infer it from the record. None of it is in the least bit satisfactory. But, you know, I hope I've dealt with that point that my Lord Reid raised. And can I move, please, to the... Now, for all of those reasons, we say that there can't be any doubt that the oral decision of the magistrate was to convict the appellants of 2 offences, and we say that any conclusion to the contrary offered by the respondent simply doesn't explain what took place below. And bearing in mind it was the respondent's own argument, it's very difficult to see how any other conclusion should be drawn. My Lord, can I now turn, please, to the...
No, you say the consequence of that is unsatisfactory, but
Yes.
it isn't fatal.
Well, my Lord, the way in which, because we don't have the equivalent language of the English Criminal Appeal Act, which simply says unsafe, we're saying unsatisfactory and we're saying it's fatal because if the process by which a conviction in law is returned is flawed, we say that it constitutes a sufficient irregularity to vitiate the conviction. And where we have the kind of irregularities we've seen in this case, we say that no court, let alone the board, should uphold the conviction.
I still feel this is Alice in Wonderland. I mean, we all know there was a breach of the enforcement notice on day 1, and also on day 2 and day 3, and so on.
Yes.
And the magistrate has mistakenly thought that the offence on day 1 was distinct from the offences on days 2, 3, and so forth. But the fact remains we're all in no doubt that an offence was being committed on day 1 as well as on days 2, 3, 4, and so on.
Yet you can't return different convictions for different days. And that's what happened here.
So, I mean, the problem you're complaining about is purely formal.
Well, my Lord, bearing in mind that for an offence like this, you can impose a sentence of imprisonment in default, this is one where the formalities matter. And although the complaint is in the correct form, there's no issue about that. There is a complaint legitimate, we say, about the verdict. If it had been returned on the complaint correctly, then there would be no complaint. We wouldn't be here now. But surely, if you are going to say to someone, here is a fine, and if you don't pay the fine, you're going to prison, you should at least get it right as to what it is you're convicting them of. And we say that that wasn't done here.
But I don't know of a single situation where a court of appeal will say, well, we're perfectly satisfied that crime B has been committed, but all the same, we're going to duly acquit you of all criminal activity.
Well, my Lord, it depends what's been charged. If, for example, you have 2 offences charging 2, and we've dealt with this in our case, charging one offence and another independently, it's perfectly proper for a court to say, well, look, one may be irregular, but the other is perfectly regular, and therefore we uphold the conviction. But that didn't happen here. And in any event, I'm perhaps spending more time on that than I had intended. What I really wanted to show, my Lords, in relation to this was how Section 18 operates. Because if we're right about the submission in relation to what offence was created and how it works, then it would follow that the conviction is unsustainable. So may I address that now? Because it may be that this takes us back to some sort of reality. If I may. Could I invite the board to look at page 386? This is Section 18 of the Town and Country Planning Act. Now, Section 18, subsection 1, appears to be quite unique in terms of the framing of this type of summary offence in planning law. I say it is unique because although the Town and Country Planning Act appears to have been modelled or patterned, as Justice of Appeal Musai explained, on the 1947 English Act, it has important differences. Section 18, subsection 1, effectively joins together what were separate offences in the 1947 Act. And the way in which it does it, and it's the last 5 lines of the actual offence created, that a person is liable on summary conviction to a fine of $1,500 and in the case of a continuing offence to a further fine of $300, and then these important words, for every day after the first day during which the requirements of the enforcement notice remain unfulfilled. And I particularly invite the board to look at the words after the first day. When we have examined the statutes that have been created in England, there's no lock-in engagement so expressly on the first day. And to illustrate the point, can I invite the board to look at the 1947 Act extract, which is at 576. And this is page 576, subsection 4. And what is striking in terms of the comparison with the Trinidad Act, there is one, it creates 2 offences. The second, a specifically created continuing offence. But in in either the initial offence or the continuing offence, is there any reference to the first day? Now, assuming, as we say the board should assume, that Parliament knows the law and knows that there are time limits that are attracted to summary-only offences, if you are going to create an offence and you make, as we say they have, the first day material for the purposes of criminalising the action at which the section is directed, then you are locking and engaging the first day as a material averment. And it's open to Parliament to do that. They can create offences where they make dates or events material. And here, when you look at the way they structured the Act, that is exactly what they did. Otherwise, there would be no reason to mention the first day. And not just mention the first day, they attract a specific fine to be imposed on the first day. This is a fine of $500. And then if the offence is continuing from that first day, a fine of up to $300 every day after the first day. So unless Parliament intended exactly the same as the English legislation, which we say is unsustainable, one would have expected to find similar language. They haven't used it.
Well, it's completely different. I mean, subsection 4 is envisaging, it's setting up 2 completely separate offences.
Yes.
I mean, one is the initial offence of a breach of planning control, for which you're liable for a fine up to £50, no matter whether it was for 1 day or for a year. It doesn't make any difference. And if you're a person who has been convicted and thereafter continues to use the land in breach of planning control, then you can be prosecuted a second time. You're guilty of a further offence, and this time you get hit with what in those daily rates in those days was a very heavy daily fine.
Absolutely. Well, we don't dispute any of that in terms of what the 47 Act says, but that it doesn't follow, which is what the Court of Appeal seemed to think, that Section 18.1 was creating 2 offences which operated in the same way as the 47 Act. And I think that's accepted now. Certainly it only creates 1 offence. But where we say that there is the critical dispute, the respondent says, but it's all right, even if you get rid of the first day, you can still prosecute for the continuing offence and uphold the conviction on that basis, but it doesn't operate in that way. Section 18 creates one offence, which, as I say, locks and engages the first day. That's why it is structured in the way it is. If that is right, then the only other question is, does the Town and Country Planning Act create a time limit specific to this offence? That's the only question we say. And I want to deal with this, my lord, because I know that there is plenty of authority which the respondent has cited against us. Some of them are in Archbold, some of them are in Blackstones, but when you actually look at the sections in each of those cases, they do not lock and engage, as I say, the first day. The closest we come to it, when we're dealing with reasoning, is the case of Maltedge. And if I can invite the board to look, please, at the case of Maltedge. This is...
Just before we do, just look at, in terms of Section 18, I mean, if this offence had been properly charged, or if a conviction had been for the proper dates, then it would have charged an offence of failure to comply with the enforcement notice for the period from the 9th of April 2008 to the 9th of October, I think. We agreed on that?
Sorry, my lord.
The appropriate period in the charge or in the conviction, whichever you like, should have been the 9th of April to the 9th of October.
Well, we say... Well, let me answer, my lord. I hope I am answering my lord's question. Yeah. The Town and Country Planning Authority clearly knew the first date was material. That's why the first date is in the complaint. This is the January date.
Well, it's going to be.
Yeah.
I mean, if you're charging for a period, there's obviously a day when the period begins. And the period could competently only have begun on the 9th of April, I think, being 6 months before the date of a complaint.
That's the date of the complaint. But there's no issue about that, my lord. What I'm saying is that the Town and Country Planning Authority clearly appreciated that the first date following the period of compliance, so your first date of non-compliance, was material. That is why in the complaint they charged that first day. And so it seems very clear that when they were...
But it couldn't charge the actual first date of non-compliance because that was outside a 6-month period.
I'm not disagreeing with my lord. What I'm trying to show is that the way in which the complaint was pleaded is that the Town and Country Planning Authority clearly appreciated that the first date of non-compliance was material to proving the offence. And we say that that's got to be right, because when you look at Section 18.1, which I've taken the board to, the period of criminality, which has been expressly created, uses the first day as a marker.
Well, it's only a marker for sentencing. I mean, all it's telling you is that if you convict a person in respect of a period, they're liable to a fine of $1,500 for day one and to a further fine of $300 for every day after day one.
Well, my lord, it certainly creates...
Well, am I not right about that?
Well, my lord, I agree with you. It creates the various fines for the various period charged. But what I'm emphasising, I don't know whether the board will be with me on it, and I haven't taken you yet to Maltedge, but the way in which the offence is framed is not, it seemed, like the English legislation, to be able to treat the first day as essentially immaterial. That you could lay the charge, as long as the offences continue, you could lay it at any time and only go back 6 months. The way in which Section 18.1 appears to be framed...
But are you arguing that they have to charge the actual first day of non-compliance?
I am arguing that they have to not simply charge the first day, but they have to lay their complaint to capture the first day.
If they allow more than 6 months to elapse from the date on which the enforcement notice expires, it's no longer possible to prosecute.
Yes.
Oh, I see. I've got your argument now.
No, that is what we've said in our case. We're saying
ambitious argument.
Well, my lord, we make the argument not because we're trying to go against the grain of English authority. We're simply making the argument on the basis of what's been created by Section 18.1. And if we are right that that first date is material, and you have to lock and engage the first date, then when you go to apply Section 33.2, which says 6 months and not after, then you have to lay the complaint in time from the earliest date, which is what we've said when seeking leave and what we've argued in our case.
If you look at section 18.1,
Yes.
the only requirement for proof for summary conviction to a fine of $1,500 up to $1,500 is that the time has expired. It doesn't require it to be proof that that is at the time of laying the offence. There's no time limit there at all.
Well, my lord, we say that you've got to construe the whole thing together, because since it penalises and gives a higher fine to the first day, it is clearly regarded by Parliament as material, not just for the penalty, but also for the prosecution of the offence. Because otherwise, you would have a situation, presumably always have a situation, where the first day you'd never be able to penalise.
Yes.
That couldn't have been the intention in framing the Act in this way. And we say that that position is reinforced because when one looks at the case of Maltedge, which is at my Lord's page 1021.
So really you're reading, in the last 3 lines of section 18.1, you're reading the first day during which the requirements of the enforcement notice remain unfulfilled. You're reading those words literally and saying that it's not proper to read into them the first day charged, during which, etc.
Yes.
Yeah.
Exactly.
Yeah.
Of course, it would be different if those words, the first day charged, were used. But that's not the language Parliament chose to use in this case. So is it material? Does that attract, we say, the 6-month time limit from the earliest date? Well, we say it does, and we say there is authority that supports that, and this is in the case of Maltedge. And can I invite the board to look at page 1021? Now, it is a slightly different case. It deals with a different piece of legislation.
I'm sorry, but just following my train of thought. If that reading is correct, then you only get one shot at prosecution. Because you can bring a prosecution within 6 months of the date specified in the enforcement notice, and if a person has failed to comply with the notice, they will be punished for their non-compliance.
Yes?
But after that conviction, it's impossible to bring any further proceedings.
Yes, it would seem to be because they were deliberately elected not to use the phraseology in the 47 Act, which does allow that consequence.
Yeah.
So it must be that Parliament in Trinidad and Tobago felt that this should be a one-off offence, and by not prescribing how the 6 months would work, you're left with the default position of Section 33(2).
Yes, thank you.
And
we'll finally let you take us to this authority.
yes, could I invite my Lord to look at 1021? And as I say, we accept that there are differences. There are differences in all of the cases. But if you look at 1021 and it's the bottom 3 paragraphs, I believe this is Mr. Justice Laws as he then was, top of the paragraph, it will be seen that the date by which an enforcement notice falls to be complied with is a defining factor in the offence created by section 1791.
Sorry, you're reading...
I'm so sorry. It's 1021.
Yes.
And it's the case of Maltedge.
Yes. And you're on page...
And it is...
Yes, I see. It will be seen. Thank you. Got it.
Yes.
Can you just give us a moment to look at section 1791?
Yes.
Yes, I see. Yeah. So all Lord Justice Laws is saying is that evidently there must have been a failure to comply within the specified time, and therefore the specified time is a relevant component.
Absolutely. And that's how it becomes material. And we say that he's distilled it in a way that is helpful to the board for this appeal. In the first 2 paragraphs, middle of the page after he deals with the section, it will be seen that the date by which an enforcement notice falls to be complied with is a defining factor in the offence created by section 1791, because that section is drafted by reference to the compliance period. And then a little further down, dealing with Mr. DeHaan's argument, that it is a material averment to plead the compliance, or more specifically to plead the date within which the compliance with the enforcement notice must have taken place. He further submits that it being material averment, it is necessary for the prosecution to prove that date, and then goes on to accept Mr. Dehaan's submission. And so I'm sorry if I've taken longer to get to it, but this is why we say, when you look at the language used by Section 18.1, that makes that first date material. Parliament is clearly using the earliest date as material for proving the offence and punishing the offence when you read the section as a whole. Now, we accept that if they had used different language, like the 47 Act, then it would operate the same way as in England. You could effectively lay the initial offence at any time once there was a breach, and if you're convicted, then it triggers the continuing offence. But they didn't use that language, my Lord. And that is why we say it cannot operate in that way. My Lord, we are again reinforced in that because in the subsequent case, which considered Maltege, which is Ceredigion, forgive me, Ceredigion. One second, Ceredigion, I'll just find my reference to it. Could I invite the board to look at 620? Because we tried to find where and how the case of Maltege was considered in more recent authority in England. And we did find it in the case of Ceredigion.
I think it's Ceredigion.
Forgive me, I'm sorry, Ceredigion. I'm grateful to my Lord for correcting me. Ceredigion. Could I invite the board to look, in this case at page 619, Now, in that case, the appellants tried to rely on the case of Maltege, except that they faced an insurmountable difficulty because the English 1990 Act had been amended. And if you look at page 619, and it may not be necessary to take you to the actual provision, the amendment was made to include the words "at any time." And not once, but several times in the Act, because it's mentioned in subsection 1 and in subsection 5. And then, for good measure, subsection 6, an offence under either subsection 2 or 5 may be charged by reference to any day or longer period of time, and a person may be convicted of a second or subsequent offence, etc. So here, the court considered Maltege, but distinguished it on the basis that the statute had been amended. And we know that when you turn over the page, where they look at a decision of Mr. Justice Singh, and it's at 620C. The ratio of the case is that the informations in that case were defective because they did not aver, nor was it ever proved before the Magistrates Court that there had been a failure to comply with the requirements of the enforcement notice, and then goes on, that was an essential element of the offence charged, yet not averred, etc. So Maltege is still good law in relation to material averment, but no longer applicable following the statutory changes in England. But insofar as it is relevant to our appeal, what it does make clear is that you can have a situation by the wording of the statute that makes an event or day material. We come back to the first day point that I've already addressed the board upon. So with that, the only question then is, well, when is the first day for the purposes of the Summary Courts Act? And it may be just worth looking at the Summary Courts Act, the relevant section that is. It's at page 418. And it's the top of the page, 418. And in some respects, it's similar to some English legislation, but it includes different wording. And it says that in every case where no time is specially limited for making a complaint for a summary offence in the Act relating to such offence, the complaint shall be made within 6 months from the time when the matter of complaint arose and not after. Well, my Lord, we say that the various pronouncements from the senior courts over the years about the construction of the legislation, the application of the language, the literal interpretation, is important here, and we've cited them in our case. And when you're construing penal provisions, that applies perhaps with some greater force, because you do not adopt the interpretation which has the worst possible consequence for the defendant. You tend to adopt one if there is a doubt in favour of the defendant. It's still the case. So if we look at subsection 2, the way it is framed, it seems very clear that it is emphasising the earliest date of any criminal offence which has not been given a specific time limit in the originating act. Otherwise, the words "and not after" are devoid of meaning, which, now I know the respondent says it is devoid of meaning in effect in this case, but we say that that can't be right, because when you are framing offences, creating offences, and you leave the default position to be governed by the Summary Courts Act, section 33(2), there must be an acceptance, Parliament presumed to know the law, that unless you make it clear and use the language as we've seen in the English legislation of laying a charge at any time, that you're going to be restricted to 6 months. And the 6 months, if the first date is material, is the time clock starting to run. Now, of course, if it weren't for that reference to the first day, the situation would be broadly in line with the cases that we've looked at, which the respondent relies on. When you actually look at those cases, and I'm going to take you, I don't think I'll have time to take you to all of them, but certainly some of them.
And in our case, the enforcement notice required the appellants to take the action specified within 28 days from the date that the notice took effect, and it provided it would take effect 28 days after service.
Correct.
And it was served on the 21st of November 05. So if we add on 56 days to that, we get a date at some point in December of 2005, I suppose.
My Lord, if it helps, I think we've calculated...
No, January. It'd be January.
I think it's 16th of January is accepted to be.
Yes, I was going to give the board a reference. We worked out the dates. It's at 314 of the record,
right.
Paragraph 31 in our case. And what we did is we worked out from the date the enforcement notice was issued on the 3rd of October, the relevant dates going further right up to the date of conviction. So that is
16 January.
I hope that's of assistance.
The time for compliance was the 16th of January, so the 17th would have been an offence.
Yes, so from the 16th onward, yes.
Yeah.
Correct.
Subject to section 33,
yes.
subsection.
Subject to section 33(2). So if, as I say, Parliament has created an offence which is one-off and which is makes the first day material, then you have to lay your complaint within the 6 months from that date. Yeah. That's what it comes to. We say then, turning now to the very large number of authorities cited against us, that those authorities cannot assist. Just bear with me for a moment. So can I deal with the case of BT, which is at page 995? I think that's the first of the authorities which is cited against us. If the very apologies, my lord. Yes, 995. What is critical in each of these cases is not that they are authority for the proposition that simply because it is a continuing offence you can lay your complaint at any time. The constant theme throughout each of these cases is you have to look at the language of the legislation before you make any judgment as to how it would operate. And we say that that is clear because when you look at 995 to 996, this creates the statutory duty, so perhaps a higher responsibility to reinstate a street. But when you then turn, I've taken you to the provision, the penal provision, but then when you turn to 996, you then go on to see how Lord Bingham approached it, and it's the middle of the page where a statutory provision creates a continuing offence, such failure to comply with creates a continuing offence, necessarily depends on the language of the provision and on its correct construction. It seems to me that caution is called for when applying the observations in one case with reference to one statute to different provisions of a different statute in another case. And then these, perhaps, words that I particularly rely on, quoting Justice Croom Johnson. As a general rule, the court is not, I think, eager to find continuing offences created by statute, and certainly not without express words which make clear that it was the intention of the legislature when the statute was passed. That seems to me consistent with the general approach in these matters that conduct is not to be criminalised unless Parliament has made plain its intention that it should. Now, my Lord, we grab those with both hands because we say that if it was the intention of Parliament to create an offence that you could lay at any time, outside of the 6-month time limit prescribed in the Summary Courts Act, they would have said so. And so, when one looks at the case of BT, whatever may be, and we did look at this, my Lord Stevens mentioned Blackstone's, we looked at how the summaries in Archbold and Blackstone's had been put forward, but it doesn't deal with this particular point. It takes what they consider to be general approaches that you can gain from these cases, but when you actually look at the cases, it's always language specific. Can I then invite my Lord to...
So, can I just...
Yes.
One might have had this complaint laid, for example, 10 years or 15 years
Yes.
after the failure to comply, and that, you say, would have been pretty monstrous.
Yes, we do. And you see, this is in part why we say the language of the Act used is important. Because if it was the intention to permit that result, it could have been done expressly by saying, simply adding the words "at any time," as the 1990 Act 171D does.
But then you're restricted in that case to the period of 6 months.
You may be restricted, but you can lay it at any time. There's no difficulty with that. But you couldn't do that in this case with the language that's been used. Then when you go...
Isn't there a safety net provision of 4 years applicable?
That's in relation to issuing the enforcement notice. So you can only issue your enforcement notice within 4 years of the building or construction. So after that, you can't issue a notice at all. But that actually, I'll deal with it now because my Lord has raised it. It's permissible to look at other provisions in the Act to determine or construe other, the provision with which we are concerned. I think it's Section 16 of the Town and Country Planning Act permits an enforcement notice to be issued, but you're restricted to 4 years. You cannot issue it after that time, in which case you're stuck. But if you do issue your notice within that 4 years, and we accept that that happened in this case, the only provision that gives the minister power to act on the face of the statute at any time is the provision in Section 17, which allows them effectively to enter onto the property and carry out the work themselves. So we say that although the respondent seeks to weaponise that against us, in fact, that's actually quite clear from the Act. The wording used gives the minister the power to enter the property at any time and recover the cost of any redevelopment or demolition as a civil debt. It's expressly provided for in the Act. And so there would have been no difficulty if the intention was to create a summary offence that could be laid at any time to use similar language to create that impression. They don't do it. So they seem to have struck a balance in Trinidad and Tobago between, on the one hand, giving you 4 years to issue your enforcement notice, that's number one. Number two, laying your criminal charge, your summary offence, within 6 months of that notice expiring, and then reserving to the minister a power to enter onto the property at any time if you haven't done the work. But each of those sections are very specific in what they say. And if, when you look at all of those together, we would say that Section 17 helps us with the interpretation of Section 18.1 because they could have used express language as they did in Section 17 to say you can lay it at any time.
Thank you.
So the answer to the point I put to you earlier, that on your approach you only get one shot at prosecution for an enforcement notice, for breach of an enforcement notice, is that you can serve a second enforcement notice or a third, as long as the breach of planning control remains subject to the long stop.
Yes, subject to long stop. But you see, this is the thing, my lord. There are various other options that are available under the Act. But what we're very clear about is that the only indefinite power is that the minister has to enter onto the property and do the work after the notice has been validly issued. That still remains his power, but we would say that it's not the point we're arguing for this appeal, but one assumes that the longer you fail to act, there may be public law considerations that would arise, that if you leave the building there for 30 years, it may become unfair to allow the minister now to carry out the work or enter to demolish it. More importantly, of course, even though they have that power, if for example, they couldn't survive a judicial review against the decision to now enter the property and carry out the work, there is also the power to compulsory purchase the property. So there are other things the minister can do and the government can do if it wishes to particularly remove a property. They're not without a remedy. But all of that speaks, my lord, to a restricted approach in relation to the summary offence, consistent with the wording that it used. And if, as a alternative submission, the interpretation is that they can lay the charge at any time because it's a continuing offence, then the appropriate course of action in this case would be to allow the appeal in light of what has happened. And if they are permitted to lay a charge again, they can lay a fresh complaint and get it right with the judgment of the board. But it would not be right to uphold the conviction in the manner in which it's been done here. I was dealing with BT. I want to, I know I'm under pressure of time. Could I invite the board to look at page 1000. And it touches on the case of Hodgetts in the middle of the page. And deals with Hodgetts and Hartsmere. However, the court came to the conclusion that it was a one-off offence and not a continuing one. And I mean, it's dealing with a different offence. But then if you look at the very next page, again, the word language always seems to be mentioned by the judges when construing these particular provisions. They're very careful. So if you look at page 1001, dealing with the Camden London Borough Council case, further, it seems to me very difficult, as it seemed to Lord Justice Henry and Camden London Borough Council, to give effect to section 95(2) if there was not, in fact, a continuing duty. And then the important words, it was the language of section 3762 that was the crucial factor leading to this decision. Penton Park Homes is the next case, which is a little further on 1094. And 1094, again, it looks at the statutory provision, which, as my lord did a moment ago, is absolutely the critical step. And where you look at that piece of legislation, this is subsection 4 in the middle of the page.
Of the Caravan Sites and Control Act.
Yes. But I take the point shortly because this is going to be my submission in each of these cases. It's the language used, and what you notice again, there is no specific mention of the first day or days as relevant to proving the offence or penalty. Now, that case, of course, created two offences. And if one looks at the dicta of Justice Bridge, which is at 1094, he sounded the same caution as Justice Collins in BT on relying on decisions from other statutes. And underscores, bottom of the page, Mr. Sullivan recognises that authorities embodying decisions of other statutes where the question whether or not a particular offence was to be regarded as continuing can only go so far in assisting the court, since this is a question which has to be decided in relation to the subject matter of each individual offence as to which the question arises. And again, it continues the theme of looking at the language. Can I take the board to Ex parte Borelli's Bakeries? This is the decision from the Supreme Court of Victoria, which is a little further on at 1100.
Sorry, page?
1100.
Thank you.
And it's the very top of the page. This is now the Labour and Industry Act 1958. No time limit or days specified in the offence. But again, when one looks at the approach of the court, it is the language that they construe. And as I say, absent those words that we find in the Trinidad Act. Verney cases, the case of Verney, which is dealt with, in fact, in this case. Just bear with me a moment, my lord.
Yes,
No, sorry, it isn't. It's my mistake. 1149. This is a case concerning the Factory and Workshop Act 1901. And insofar as it's relevant, the reason the complaint was found to have been laid in time is that it was laid within the 3 months required of the knowledge of the appellant. But again, if one looks at the actual section is extracted in the footnote, my lord, at the bottom of 1149. And again, strikingly absent is any lock and engage type provision for the first day. And then when one looks at the way in which the case was approached, 1151, so it's a little further on, Chief Justice Lord Alveston, the same warning shot is fired off when one is dealing with a potential interpretation for a continuing offence. I am of the opinion that the decision of the justices was wrong. I do not wish to press unduly against the respondents the admission that in ordinary circumstances the offence with which they were charged would be a continuing offence. I prefer to deal with the language of the Act itself. So, again, even in Verney, there is no short circuit, so to speak, in relation to when the offence or how the offence will operate. It all depends on the language. And then we come to the case of Hodgetts, which my Lord Reid mentioned to me. And again, in relation to each of these offences, insofar as what they decide and how they construe the particular offences in those cases, we don't have any submission that we would wish to make. They are confined to the operation of those particular offences. But when you actually look at Hodgetts, which is at page 1084, this is section 89, subsection 1, and you can see that unlike the Trinidad Act, there is again no particular attachment to the first day, or when the compliance period or non-compliance period began. The same can be said of Camden, which is at this is Camden London Borough Council, which is at 1016. And again, they're construing the penal section 376. You can see that there is again no reference to what we say is the lock and engagement provision in the Trinidad legislation of the first day. So clearly you can lay it at any time as long as the offence is continuing. That flows from the language used in the Act.
I mean, it's easy enough to do that in a case like the one about the unfenced flywheel.
Yes.
Where clearly you can go into the factory on a given date and see that the flywheel isn't fenced, and that's a distinct offence. Now, your only answer to the objection that if you're right, then once the 6 months beginning with the expiry of the enforcement notice have passed, you acquire effectively a right to have your property in breach of planning control for the rest of time. Your answer to that is that a second enforcement notice could be served.
Potentially, yes. I mean, you know, subject to the powers the minister has.
Well, exactly. That's I'm wondering. When you look at section 16 is the power.
Yes, the restriction of 4 years, I think, my lord.
Page 383. Yes, and a notice can be served where it appears to the minister that any development of land has been carried out after the appointed day without the grant of permission required under this part. So it's because that appears to the minister that the first enforcement notice is served. Don't you have to rather strain that language to say that the same thing can appear to him for a second time following the conviction, which, on your approach, the one conviction which is possible?
Yes, you would have to strain it, and that is why I say you shouldn't strain the language in section 18.1 to reach the position that you could uphold these convictions. I mean, the problem is, my lord, can I deal with it in this way? Because of and I suspect it is because of this, we try to find some authority that deals with it. The development of land in Trinidad and Tobago, because it was a sugar-producing state at one time, means that there were many different considerations that applied to the development, both urban, suburban, and rural. The only real urban area was Port of Spain, the capital, and anywhere outside of it was effectively rural cane lands. But the board is aware, I think, from other cases. I think my Lord Stevens may have been in one of them, where the application of a piece of legislation, we've mentioned it in our case, the Land Tenant Security of Tenure Act, was specifically passed in Trinidad and Tobago to protect houses which had gone from being the wooden chattel house which could be moved to now an immovable house because of the way things had developed. Now, strictly speaking, all of those houses should have had planning permission. But Trinidad and Tobago didn't require that, or if they preserved that right in the Town and Country Planning Act, they've certainly, from any case I found, not tried to enforce as against them. But all of these lands started off in some way, shape, or form in that way. And so what we would say, there may be very good reason why in Trinidad and Tobago they restricted the prosecution of criminal offences to 6 months, because otherwise it may not have reflected the unique conditions in Trinidad and Tobago at the time. And this legislation, I think, was passed in 1960, when the chattel house problem was still a major problem. Now, it couldn't have been right to prosecute someone who had built a chattel house and then it became an immovable chattel house. There may have been very strong objections to issuing an enforcement notice against them and then prosecuting them. And so what seems to have happened with this particular act, at the time it was passed, and the way it operates, we say even today, is that the Trinidad Parliament has struck a balance between creating a criminal offence that if it arises, you prosecute it within 6 months, and if it doesn't, you've lost your opportunity. But it doesn't mean, once your enforcement notice has been issued in time, that the state is without a remedy. And I address my Lord Lloyd Jones.
Eventually, the state would be without a remedy, wouldn't it? Because even if you miss the 4-year time limit, you can't serve another enforcement notice.
Yes.
Okay. And then it would have to be sequentially. If passively a person doesn't comply with the enforcement notice, the initial one, you would have to sequentially keep on issuing more and more enforcement notices within the 4-year period.
Unless, as my Lord Reid says, that you have one opportunity to do so. And I think my Lord was asking me about the section. So it effectively says, look, Town and Country Planning Authority, we are giving you all of these statutory powers. These are the periods in which you have to exercise them. But if you don't, let's say it was exactly this property and they never issued an enforcement notice, there would be nothing they could do, even if it was built without planning permission. So this is why we say, construing the summary-only offence, and I emphasise, my Lord, one of the changes that happened in England is that they made the summary-only offences tribal either way. So time limits fell to the wayside after that. That has never happened in Trinidad and Tobago. This remains a summary-only offence. So that's got to be the strongest indication from Parliament that they are not intending to create a summary-only offence that can be laid at any time. There must be some kind of expedition that they're saying you've got 4 years to issue your notice. That's the civil side of it. And then if you haven't complied with it, you could be liable to a criminal offence if we lay a complaint. But we do it, again, within a short period of time. That's 6 months. And that, we say, is the reasonable interpretation when you are construing a penal statute on the language used in Section 18.1.
There's a continuing obligation to comply with the enforcement notice.
There may be a continuing obligation. That's certainly what the Court of Appeal considered. But for the purposes of the criminal offence, that's a separate point, we would say, because the criminal offence cannot be used, and I'm going to take my Lord to a judgment that seems to touch on this, cannot be used as a means by which to force the owner to bring down the building. The summary offence is simply to criminalise certain behaviour. And can I take the board to that now? Just Kennedy.
Just assume on your analysis the procedure is followed as you've indicated, and the matter is brought on a summary basis relatively quickly.
Yes.
What would be the appropriate order for the magistrate to make in respect of the continuing offence, assuming, as at the date of the hearing, the building had not been restored to its original state?
To answer my Lord, once they brought their complaint in time, within the period we say that they have charged, if there's no other defence and you can prove it, then all the magistrate will do is issue the fine.
But in respect of a particular period up to the date of the hearing, or in respect of the period of the charge, or what?
We would say in relation to the charge laid in the complaint, so the period specified in the complaint. That's what we have argued in our printed case. We say that you should not be permitted to go outside of it, absent clear language in the Town and Country Planning Act that permits that result. Certainly there's nothing from Trinidad and Tobago that would suggest that that is an approach that has been adopted. This appears to be the first case in which it was done. But I would not regard this particular case as precedent in any way, because one of the mistakes that was made is, despite the magistrate being shown ex parte franks and the Court of Appeal, they even disregarded the fact that you can only go back 6 months anyway.
But if your client in those circumstances were to disregard the enforcement notice, despite having been convicted of the offence, what remedy is there?
Well, my Lord, once they've paid their fine, assuming they have, you cannot then go back again to lay another charge on the way Section 18.1 appears to be framed.
Even if the building isn't remedied, that's that.
But that's in criminal process. But the minister still has the power, once the enforcement notice was issued, to enter onto the property and knock it down.
I see.
If they wish to.
Yeah.
But what we say is that the way in which each of these provisions operate And we urge the board not to look at the criminal offence as a means by which to bring down the building. And we say that that is so because otherwise...
But it's a continuing failure to comply.
It's a continuing failure to comply, which the minister can take action with once the enforcement notice has been issued to bring down the building, if they wish to do so, but not to put the defendants at risk of a criminal conviction. When it comes to that, that is restricted in time. And if they want, and perhaps after this appeal they might, if Parliament wants to make the offence either way, or simply includes the word at any time, as we have in the 171 Act, there's no difficulty with that, because that would cure the problem. You could lay your offence at any time. My Lord, can I invite
The problem about the idea of having a number of enforcement notices is that the same thing can't appear to the same person twice, I don't think.
Sorry, my Lord, I didn't...
we have got on the one hand the possibility that once the 6 months have passed from the final date for compliance with the enforcement notice, once that period has elapsed, the owner of the land is free to flout planning law forever. That's not a very attractive conclusion. The alternative to it is that it's possible for a further enforcement notice to be served.
Yes.
The difficulty with that is that in order to serve an enforcement notice under Section 16, the breach of planning law has to appear to the minister. And it's difficult to see how something that appeared to the minister in year one
Yes.
can appear to the minister again,
Yes.
like Gabriel appearing at the Annunciation, on a subsequent occasion.
I agree, but the remedy there, my Lord, insofar as one talks about, I use the word remedy, I don't mean remedy. What I mean is, if it is the intention of Parliament to, if you like, change the law to cover situations that you can issue an enforcement notice at any time or bring a summary offence at any time, that is a matter for Parliament. They cannot ask the courts to strain the language, if not break the language, to make a person liable for a criminal offence unless the Act does it itself. And perhaps the warning shot in relation to that is in the case of London County Council versus Wobbly.
Just before you go to that, as I understand it, your only answer to the two situations put to you by my Lord a moment ago is to say the minister can enter on the property.
Yes, once the enforcement notice is in time. That is still an available power to the minister. Yeah. So that is not lost once the enforcement notice was issued in time. Yeah. So let us say that for whatever reason, that was a step that needed to be taken. That is preserved expressly by the language. There is no restriction in time for that.
Well, Penton Parks, there was a restriction in time because the licence, this is at page 1094 and 1095, the licence required compliance within a certain period of time.
Yes.
And Mr. Justice Bridge said, bring common sense to bear on this, the failure to comply, that is to say, with the condition requiring the site licence to work to be completed within a specific period, is a continuing offence. And he said it would be a very startling conclusion to suggest that the machinery for enforcement of a condition of this kind would be conspicuously defective.
Well,
that interpretation.
Dealing with a differently worded statute, certainly for the summary offence, it seems that you could have laid that within any time once the offence is continuing. But again, even that piece of legislation, the Caravan Sites and Controlled Development Act, did not, and I can only emphasise it, lock and engage the first day.
Well, the licence did.
But not the offence.
The licence required it to be done by a certain date.
Yeah, that's the period for compliance, yes, I accept that.
Yeah.
Accept that. But the period for compliance here is only relevant for the purposes of this appeal because it helps in identifying when time would run for the purposes of the summary offence. But can I invite my Lord to look at 1158, which is the decision of London County Council versus Worley? This is the decision of Justice Kennedy, which we do place some emphasis on because in construing the language in that case, Justice Kennedy stated this: "I feel compelled by the language which has been used by the legislature to come to the same conclusion." So again, critical the use of the language. "And I therefore concur in the judgment which has just been delivered. At the same time, I feel some hesitation, for there might be cases which might afford temptation to a local authority not to use due diligence in enforcing the provisions of the Act, for if they can wait, as I think on the language of the Act they can, they might put enormous pressure on an owner, for they might let a building be run up and afterwards proceed for penalties so as to compel the owner to pull it down."
Well, that would be an abuse.
Well, absolutely. And so what we're saying is that the summary offence is not designed to do that. It's not designed to bring about the taking down of the building. It's simply creating a criminal offence. In this instance, it appears once charged and proved, that's the only offence you've got in relation to the defendant on that occasion. Okay? But it is not, we submit, intended to cause the owner to pull down the building. They're simply criminalising his failure not to do so. And here, although I'm going to move on to sentence shortly because I know I'm limited in time, one of the things that has never been asked, but we've highlighted in our case the various pieces of information Town and Country had, they have never explained why they took until 2008 to lay this charge, and in fact had knowledge going back to 2002. So there was every reason, we say, to be able to lay the charge within 6 months without any difficulty at all, even if it meant making 2 visits. Day 1 of non-compliance and the day before that period were to end. So they could have laid it very easily within that period. And absent any explanation or submission that's made as to why they should be able to delay, we say that the words of Justice Kennedy are perhaps of some importance here, because you shouldn't be able to use this piece of legislation oppressively. If someone's committed a summary offence, the norm, summary offence charged quickly, dealt with quickly in the Magistrates Court, none of which happened in this case.
That argument wasn't raised below?
No, it wasn't, but I raise it now very humbly, my Lord. My Lord, I've taken you to some of the cases. I know I'm limited on time. Can I give you the references for the others, which goes to the same point about focus on language? So it's the case of Camden London Borough Council versus Marshall. This is at page 1016. Thank you. That case concerned safety and hygienic conditions, multi-occupation. Focus on the language. The case of Smith versus North Somerset Council. This is at 857 to 858. And could I invite particular attention to 858 paragraph 5, where the time limit in that case concerning the relevant statute in 1162 created a certificate regime for the purposes of addressing the 12-month time limit. So in other words, it reserved unto the prosecutor, once I issue my certificate that I have knowledge, that's decisive as to when I have knowledge for the purposes of time running. So very different legislation. Rowley versus Everton, which is at 1124, does not assist at all, since that case was determined by Lord Caldecott, Chief Justice, on the basis that the offence was committed within the time alleged in the information. That was 3 months. And what was rejected in that case at E1125 was the argument that was made there that the machinery and plant were first operated not later than 29th of August 1939. So it was a slightly different issue before the court on that occasion. The defence were trying to make a defence out of the fact that the machinery and plant were first operated at a much later date. Can I turn now to some of the Trinidad authorities? And I need to deal with this, my Lord, because something's gone wrong in how they might be viewed. Resende's breeding and boarding case, which is at 1073, this was an employment case To the extent that it is relevant, it supports the appellant's position because it does not lock and engage the first day of non-compliance. In fact, the language there was clear that the mere fact of a neglect or failing to pay would give rise to a continuing offence. In relation to Resende, again, a degree of caution, because the Trinidad Court of Appeal in that case seemed to rely more on the editor's note, which is at page 1075, without actually going into some of the detail of the legal principles. Now, in relation to Singer sewing machine, this is just not applicable. This is at the board's page E1117. And similarly, the case of Skinner versus Mary Ewan at 1087. Basically, my lord, there's a bit of confusion here. The way in which those cases were summarised in those judgments was to look at continuing offence in the context of the summary ejectment ordinance. It's totally different, one might say chalk and cheese. The summary ejectment ordinance operates in a very specific way. If the notice to quit has been issued and the tenant does not leave, the landlord can go to the Magistrates Court in its petty civil or petty civil jurisdiction and say, I lay a complaint on oath that this tenant has not left. The magistrate can then issue a summons to bring the tenant to the court, and then, if they cannot show cause why they should not be ejected, the court issues an order for ejectment. It has nothing to do with summary offences, and it has nothing to do with continuing offences. And so that we make good on the point, can I invite the board's attention to the case of Isaac versus Francis? This was the authority we sent through yesterday. And it deals with all of this in very significant detail and explains the operation of the various sections. It is not concerned with a summary offence. So, as I say, the board can disregard them. My lord, the final case of Cook and Cook, which is at 1130, I would invite the board to look at, please. The respondent places some reliance on this case for two reasons: continuing offence and also to deal with the way in which Section 33, subsection 2 works. But as you'll see from 1130, this is concerned with an order that had already been made by the court for maintenance and a failure of the husband to comply with it. So it's similar to the considerations in Skinner versus Mary Ewan and Singer sewing machines. It's really concerned with enforcing that order. It's not actually to do with a summary offence at all. And as far as it concerns the wording, which is at 1131 of, in that case, Section 210 of the Justices Act, where Section 210 is in similar terms to Section 33.2, the judgment does not actually deal with the proper interpretation of the words "and not afterwards." The case didn't concern that at all. So you will gain no assistance, we say, from that authority. But what you will gain assistance from is the judgment given by Chief Justice Knox and Stark, which begins at 1133, and the relevant part is that they summarise the circumstances in that case. And if you turn over the page to 1134, and it's about a third up from the bottom after the case of Davies and Davies, the means of effecting that policy must depend upon the provisions of the Act itself and not we should have thought upon the private obligation of the parties. And essentially, if I can take you to 1136, this deals with the limitation section in their legislation. Middle of the page, we do not, this is just before the end of the judgment, we do not think it is necessary to determine whether an order upon an information charging disobedience of a maintenance order is an order in respect of an offence within the provisions of section 210. For assuming that it is still a disobedience, the maintenance order is a continuing act giving cause of complaint. So it has nothing to do with summary offences. It has nothing to do with how the board should construe section 33, subsection 2. My Lord, I think I'm almost at the end of my time. Can I deal with these and simply give the board the references? The respondent has sought to rely on various provisions of the Summary Courts Act, section 144, section 145, section 118. And going back to the beginning where my Lord Reid was asking me questions about the complaint, there's no defect in the complaint. So none of these sections can actually help in this case if the decision is erroneous in law, which we say it is. Those are simply matters that if, for example, a mistake was made in the complaint or the drawing up of an order, then those things could be corrected. But this is why I took the board very early on to what the oral decision was and why that is important, and of course that the complaint itself doesn't contain a defect. So you can get no assistance from those provisions. They are not, as applies to indictable only offences, the equivalent in Canada of proviso provisions. So there's no proviso to be applied here. My Lord, in relation to sentence, there are two arguments which we make. The first is in relation to imprisonment, and what we say is that it is clear that the magistrate proceeded on the basis that that was mandatory. That's been accepted by the respondent, and so I don't say much more about that. But where the respondent says there is no reason to think that the Court of Appeal made the same error, well, with respect, we say that that's unsustainable, because when you look at the reasoning of the Court of Appeal, they don't deal with sentence or why a sentence of imprisonment is appropriate at all. They simply say hard labour is not appropriate. So it's perfectly possible that they would have concluded, well, imprisonment was mandatory, but the only discretionary bit was hard labour. Now, unless you have reasons from the courts below that indicates why they thought a sentence of imprisonment was mandatory or discretionary, we cannot assume that they gave any consideration to that at all. And in any event, we would go further. Why in this case would it have been necessary to fix a period of imprisonment in default? The respondent accepts it was a discretionary power. So where are the reasons for exercising the discretion to say, if this is not paid, imprisonment must follow? That must be, as a minimum standard, even if it's in one sentence, my Lord, the reasons are as follows. And you don't have any of that.
And the period of imprisonment is dictated by the size of the fine?
By the size of the fine.
And the size of the fine, in turn, is dictated by a massive delay, which is unexplained.
Absolutely. It is not explained.
And if the matter had been brought on promptly, the fine would have been smaller. Is there a threshold below which you don't go to prison for not paying a fine?
I don't think there is. I think there is the way in which the legislation is structured, my Lord, it gives you a table, in effect, to say, well, look, these are the various figures. Yeah. I'll double-check that, but can I double-check that and come back to you in a moment, my Lord? Could you just double-check that? I think we have included it in our case, if yes, that is of assistance. My Lord, that deals with the imprisonment part. We say that unless a sentencing court, and it's common practice, certainly in the Crown Courts in England, if the custody threshold has been crossed, you say it has been crossed. If you're going to pass either a suspended sentence or impose a period of imprisonment in default, as we've shown in our printed case, the Summary Courts Act interprets even a default sentence as a sentence of imprisonment. Therefore, reasons have to be given. They were not, and therefore that, we say, should fall away. In relation to the delay point, well, we've addressed that. We say that there's unexplained delay here, and in any event, a way in which to deal with that would be to confine it to the period in the charge sheet. So in other words, you wouldn't be adding on 10 years in effect of fines. And that, we say, is... thank you very much. I'm grateful to Ms McGibbon. It's page, my Lord Stevens, page 308, which deals with the rate of fine and then the period of imprisonment. So the answer to my Lord's question is, if it's below $40, it doesn't appear to attract a sentence of imprisonment. My Lord, in relation to the point about ex parte franks has been made about only taking the 6 months from when the complaint was laid, but we say it goes further for the reasons in our case that you can only go with a period that has been charged, and that unless there's a statutory provision that says you can do otherwise, the case of Camyab, which my learned friend refers to, is a case from the English Court of Appeal. That case concerns the Proceeds of Crime Act, my Lord, as I understand it. So you're dealing again with different legislation, different purposes, and so you will not get assistance from that case. My Lord, finally, in relation to implying reasons, we feel that we have covered in the submissions we made the importance of a magistrate giving reasons to the Court of Appeal that could be scrutinised, because it may very well be, my Lord, that had reasons been given, everybody's mind would have been crystallised for the purposes of the appeal to the Court of Appeal. And we say that it was incredibly prejudicial to the appellants in not having a decision in particular on the law as to the offences with which the magistrate was concerned versus the single complaint she had versus the sentence she then imposed. And that is a minimum standard of fairness, but also that we say vitiates the conviction as well as the sentence in the way we've described. The absence of reasons could be fatal. There are two cases where the board has considered this point. Forbes is one of them, which I give the reference. It's 1012. And Cedeno versus Logan, which is, I think, at 891. And it is not automatic that if reasons are not given, what it comes to is this: it's not automatic if reasons are not given that the conviction is necessarily to be set aside. But it must depend on the issues raised in the case before the court. And if it shows a serious departure from due process, the failure to give reasons, then the appeal could be allowed on that basis. And so we rely on 1012 in Forbes and 891A in Cedeno versus Logan. And I would say this: it's very easy to say now how simple the case was and the provisions were to construe. They clearly weren't. The Court of Appeal approached this as a point of law of general public importance. And so on all of these bases, the board has almost an embarrassment of riches to say that the conviction has been vitiated. So, my Lord, I'm told by Ms McGibbon I'm out of time.
Well, I haven't stopped you. You're simply eating into your reply time.
Yes, and I accept that, and but I've always kept to times before the board in 20 years, so I don't intend to do different. Can I assist the board further?
I think not, Mr. Bahari-Lal. Thank you very much indeed. So, Mr. Strang, you have slightly longer if you require it.
Thank you, my Lord. Well, starting with the nature of the offence, the appellants agree at least that the offence can be a continuing offence in the sense that it can be committed over a number of days, so long as the requirements of the enforcement notice remain unfulfilled. But their argument is that it's not really a continuing offence, in that even when the offence is continued, so that an offence is committed on each successive day after the first day, a complaint can only be made within 6 months of the first day of the offence. And the implication of that is that although an offence may be being committed on later days, later than the first day, no separate complaint can be made about any such day, even though an offence is being committed on that day. that is separate from a complaint about the first day. So the appellant's argument is this is not really a continuing offence, it's a one-off offence. Or at least if it's a continuing offence, it's different from all other continuing offences.
It's an offence for 6 months. A continuing offence for 6 months after the relevant day.
Indeed. So what I propose to do first is look at the nature of the offence under Section 18.1 and what it means to be a continuing offence and why this is a continuing offence under the Act. And then consider how that relates to the statutory time limit for making a complaint, and then deal with the appellant's reasons for saying this is different. And then I will go on to the question of whether the magistrate convicted the appellants of one offence or two, and then deal with the question of reasons and the appeal against sentence. But starting with the Act. And if I may, I'll just go through the provisions starting at Section 8, page 373 of the electronic bundle. And that's just the basic provision, no development without permission. Section 8.1. Permission should be required for any development of land. And there's your distinction, by the way, my lords, with the case of London and Worley that my learned friend showed you, where he alerted your lordships to the danger of a local authority allowing a development to go up without giving somebody notice and giving them notice later that it's in some way non-compliant. There's a distinction here, is that you always need permission to make a development under the Town and Country Planning Act, and you can't develop without permission, so you should be asking beforehand. And that said, of course, Section 14.1 provides that the power to grant permission includes the power to grant permission for the retention of land, retention on land of any development that's already been begun or completed. So you can have retrospective permission, but of course somebody who's built before permission knows that they're taking a risk. And then Section 16.1 is the enforcement notice. My learned friend's taken you to this provision. But, just a reminder that it's within the minister's discretion whether or not to issue an enforcement notice. And my learned friends made the point that the power to issue an enforcement notice is limited in time, with the suggestion that affects the power to bring a complaint also, with the suggestion that it follows that the power to bring a complaint should be limited in time as well. And the answer is there are distinct stages in the statutory framework. Under Section 16.1, the minister has a discretion whether to impose an enforceable obligation upon somebody. He can decide whether it's expedient to do so, and he has 4 years in which to decide. But once he's imposed an enforceable obligation on someone, the time limit in Section 16 of itself is no reason to suggest that that obligation, that enforceable obligation, is limited in time. Section 17.1 is the power in the minister to enter on the land.
So under 16, subsection 2, the minister can issue what's described as a do notice and also a desist notice, is that right?
Yes, my lord.
And this one was purely a do notice?
Yes, the distinction between a do or a desist doesn't assist as to whether the offence is a continuing one.
Yes, okay.
That question is determined, I say, by the language of the provision and by whether the obligation continues. I should say, while we're on Section 16.1, I should just point out that after an enforcement notice has been issued, subsection 4, then there's the option of seeking permission, which suspends the enforcement notice for as long as that option is taken. And then there's the option of appeal under subsection 6, and neither of those options were taken in this case. They may become, those become relevant when I'll show you the decision of Mr. Justice Wolfe in one of the cases that I'm going to go to. And then section 17.1 is the minister's power to enter and do the works. The ministry can do the works itself and make the landowner pay. The point I take from that is that power is limited, not limited in time. I accept that there's an argument, the argument made is that that power can cut both ways. It's an option to the ministry in the event where the enforcement notice no longer has currency and no criminal proceedings can be brought. But the submission that such a power in the ministry leads to the conclusion that the offence is a one-off offence was rejected in the Penton Park Homes case, as I'll show you later. And the final one, apart from section 18.1, the final the section I'd like to look at is section 19.1. That's at page 387. And that says, that provides that compliance with an enforcement notice doesn't discharge it. I say that's significant.
And what is the purpose of that? I mean, assuming there is actual compliance, what is the purpose of this provision?
The purpose is, as your Lordship will see from subsection 2 and 3, that if you comply and then put the same thing back up,
Oh, I see.
you can...
Well, one might say that's hardly
A new
compliance.
enforcement notice doesn't need to be issued.
Yeah.
But I would say the enforcement notice is always speaking, in effect. So turning to section 18.1.
Well, I wonder if that might perhaps be a convenient point to adjourn.
Yes,
We can
indeed.
Turn to it at
Stop
2
there,
o'clock.
Yes.
Very well, we'll adjourn now and resume at 2.